So in your materials, normally Professor Rob Wilcox does this portion. So you should have his or super duper awesome outline in your materials. These are extremely helpful. I would strongly encourage you to look at them and review them. Today we have an hour and we're going to kind of scratch the surface of the broad ethics for you to consider. We're not going to take a deep dive into anything specific. We're just going to cover kind of the broad outline of what you do. I think yesterday morning you all started with Chris Galzo, and it was, I've got the file, now what? And so we kind of talked to you about what to do when you first get the case. And what I want to talk to you is from an ethical standpoint of what you do when you first get the case through to the end of it. So that's what we're going to do. And the first thing I like to start with is who's in charge? I've got this client file. I have this client. Now I have to ask who's in charge of what's going on here. Rule 1.2 of the Rules of Professional Conduct set up this scope and this division of authority. The client is in charge of certain things. The first and most important is the objectives of the representation. Now, all of my clients, the objective is get out of jail. Sometimes we have to refine the objective with the client and help us better understand what their true goal is. But the client does get to decide the objectives, whether to enter a guilty plea, whether to waive a jury trial, and whether to testify. So this is important, obviously, when the client is sitting right beside you and you can have these conversations. But this is also important for those of you who may find yourself in a TIA. What can you do when you've got no client who shows up for trial, but you think this is probably better served as a bench trial? You know, sometimes you find yourself in that situation. You got a good judge you think might be better as a bench trial. Can you unilaterally waive that client's jury trial if the client's not there? No, you can't. You got to pick 12 or pick 6, put them in the box, and you got to try that case, because whether to waive the jury trial is for the defendant and the defendant alone to make that decision. And then finally, whether to testify, that also has to be the decision that the client makes. The lawyer is in charge of the means to achieve those objectives. So as I said, the client decides the objectives. You get to decide the means to pursue those. So that could be a trial strategy. It could be what witnesses to call, and it could be what evidence to present. So you get to make all those strategic calls. Want to point out a couple of things, pull them out of Rule 1.2 in the case law. We're going to talk about this again later, but I like to talk about it here as well. Filing an appeal under Jones versus Barnes, that's an United States Supreme Court case. It's the accused or the defendant's ultimate authority to decide on taking an appeal. So even if you think it's totally baloney, you don't get to make that call. It's the client's call. And this is a recent case, McCoy versus Louisiana, from the United States Supreme Court. You also cannot admit the client's guilt. So let's go back to that TIA situation we had before. Let's say the client's charged with a couple of things, maybe a burglary, maybe also a possession of stolen goods. There's some problems with those two charges being together anyway. But what if you wanted to strategically admit the receiving stolen goods or possession of stolen goods, but not admit the burglary? Without the client being there, can you do that? No, you absolutely cannot. You might see this come up, DUIs and failure to stop for a blue light, where you want to admit the failure to stop but not the DUI. If the client isn't there and the client doesn't agree to your strategy, you can't do it. If the client is there and the client says, hell no, admit nothing, which would be me if I were your client, you still can't do it. McCoy versus Louisiana. Even if you think it's the best strategy, you can't do it. McCoy was a capital case, and they thought the best strategy would be admit guilt and hope for life. And McCoy said, no, I don't want you to do that, but his lawyers did it anyway, and the United States Supreme Court said you can't do that. Even if it's full-hearted, you still have to challenge guilt if that's what your client wants. So most of our cases are pleas, right? Hugh told us there aren't so many trials in South Carolina. He gave us a number a little while ago. Mostly what we're dealing with are guilty pleas. So what do you do when you get a plea offer from the state, from the solicitor, unless you're in the 14th Circuit? We found out yesterday they don't do these. So I'm not talking to y'all, I'm talking to everybody else. So if the prosecutor does give you a plea offer, you must give it to your client, right? Got to convey that plea offer and do it before it expires. I don't think I have to say that, but case law proves me wrong, so I'm going to say it. Give it before it expires. This is under the rules. If it's a decision the client has to make, Rule 1.4 says you have to give it to the client. And then we have Supreme Court case law. They were under Strickland, so they dealt with ineffective assistance, but you have ethical responsibilities there as well. Now, this is not a silver bullet to force the state to negotiate. We know the state does not have to negotiate, but based on the conversation we had yesterday about taking this position of no plea offers, that type of thing, I'd suggest looking at Ethics Advisory Opinion 1402. In that case, the municipality wanted to hire a contract prosecutor to prosecute the municipal level charges, but the municipality wanted a stipulation. The case must go to trial as charged unless the arresting officer or supervisor reduces the charge. And the advisory committee said, no, you cannot hold that position as a lawyer because Rule 3.8, the special rules for prosecutors, say you can't prosecute a charge if you know there's no probable cause. So the municipality's decision of they have to go forward unless the police say differently was contrary to Rule 3.8a, and the advisory committee said, sorry, lawyer, you can't hold that job. So this is not going to be a silver bullet to force the solicitors to negotiate. But if you have solicitors doing things such as, I have a strict policy of X, Y, or Z, you may want to look at this and see if it provides you any argument that you could take to the solicitor to perhaps convince them to give you a plea deal. They don't have to give you pleas, but they also can't take positions that are contrary to the rules of professional conduct. Sometimes we're dealing with this more and more as the criminal justice system has become the mental health provisions for individuals in the community. So we're seeing more and more people in the criminal justice system who have diminished capacity. And the rules do address this. Rule 1.14a, they tell us that we have to treat that person as we would treat any other client as much as possible. There may be times that we can't, but otherwise we do. For example, all of our clients get to decide whether to testify. That includes the client who has diminished capacity. So you wouldn't treat this person differently just because of that diminished capacity as far as reasonably possible. I do want to highlight B. If there is a risk of physical, financial, or other harm, you can take reasonably necessary actions to protect that person. This is when 1.6, the rule of confidentiality, also rears its ugly head. And if you find yourself in this situation, talk to a superior, call me, I'm happy to talk to you, or find an ethics expert that you want to consult with on what you can reveal in order to get this person help if you find yourself in a 1.14b situation. Sometimes there's information that we might have to provide to the court to get our clients evaluated from DMH or DDSM. And so you want to read 1.14 carefully in conjunction with 1.6 to make sure that the information that you're given is reasonably necessary in order to get that protective action. All information given is not going to be reasonably necessary to achieve that goal. And then 1.146 also is where you're going to find, or 1.14C is where you're going to have that mention of 1.6 that I was just talking about, of what you can reveal and what you can't reveal. And 1.6 has that impliedly authorized little exception, and that's where you're going to fall when you're in 1.14 territory. All right, sometimes this happens, right? Our clients insist on taking the stand to testify, and the client is going to lie. Well, we know that we have duty of candor to the court. What do we do when our client wants to lie? Has anybody found themselves, you're all relatively new, so you probably haven't found yourself in this situation yet, but you might one day. The rules do address it. 3.3, that's where we find our duty of candor. It says that a lawyer shall not knowingly, and I put that in italics because I think that's pretty important to trigger the rule, offer evidence that the lawyer knows to be false. So we've got a lot of information there that we can't present evidence that we know is false. So if you know the evidence is false, you can't present it. Do you know that it's false? Were you present on the occasion when this happened or didn't happen? I would err on the side of giving your client the benefit of the doubt when it comes specifically to the client, because remember, that client has the absolute ability to testify. You can't control that part of it. And we'll talk about that in this Goodwin case. So Goodwin was a 1983 case here in South Carolina. It all dealt with the lawyer knowing that the defendant intended to lie. And this is where we get the narrative. You may remember that in law school, learning that a criminal defendant cannot be barred from taking the stand, even if everybody in the courtroom knows the defendant's going to lie, because that is their absolute constitutional right. And so what Goodwin says, and you can find this in the comment as well, it's comment 7 on the second slide. You put your client on the stand and you have them testify in the narrative. Again, I would tell you, err on the side of you don't know necessarily what happened and what's true and what's false. Maybe if there's irrefutable video evidence that you've seen that you can't get past, but use that definition of know pretty firm to mean that you have to know that's false. If the client says, well, I'll just lie, oh, well, shit, now we're in trouble. I wish you hadn't said that, but the client said it, so now we got to deal with this 3.3 problem, and you got to put them on the stand and have them testify in narrative. But if you can avoid the narrative, I would do my best to avoid the narrative. I don't think the narrative testimony is good. Yes, ma'am. Yeah. It would be both, is my understanding. I don't think there's any clarity in the comments or any case law. I would have to look on that specifically. I think it would cover both in that the rules tend to be broadly interpreted, especially duty of candor. So if you had constructive knowledge, which would be like that video that you saw. Now, if they just had a ton of circumstantial evidence against your client, I don't think that's knowledge that the testimony is false. But if you're prepping the client and you're saying things like, well, you need to explain this video, and the client says, well, I'm just going to lie, that's when we get into this terrible territory of 3.3. And you want to dissuade them from lying, that would be your first plan of attack. Let's don't lie on the stand. Let's don't do that. Tell them the consequences of it. You don't want to do that. Instead, let's come up with a plausible explanation of the video. Let's come up with a plausible explanation of these text messages or historical cell site location information. Let's come up with something plausible that we can tell the jury about these things. Or maybe this is why you shouldn't take the stand at all, because you haven't been able to convince me, somebody who's on your side, of that explanation. Yeah. Yep. Oh, yeah. Yes, when you look at Goodwin and cases that also deal with other witnesses, so if it's a witness other than the defendant that they want you to testify, the bar is lower. It's just reasonably believe that it's going to be false, and then you don't have to put that person up. Remember, you control the witnesses who are called. So if you reasonably believe that person's going to testify falsely, you don't have to put that person up, and you shouldn't under 3.3. The defendant is in his or her own special category because of that constitutional right to testify that we can't prevent them from doing, no matter how bad of a train wreck we see coming. So when you have the client on the stand and you're asking those questions, I would absolutely do everything you can to avoid any of the information that you think the client might tell a lie about. And then the case law Goodwin also tells us if false testimony does come out, you absolutely can't use that in your closing. You need to try to get your client to correct it. And then if the client doesn't correct it, you're going to have to correct that with the judge. So you want to make sure that as best you can, you keep away from that. Now, if it's the narrative that has already signaled to everyone this is bullshit, you don't have to correct it because you've already signaled to the judge, to the solicitor, I'm not vouching for this. And so everybody knows in the narrative. But again, try to avoid the narrative. You have to know that it is false. Yes, ma'am. Well, I think you would work that out with impeachment evidence. Right. No, you're not putting that witness up. You're not putting your name behind that witness. You're not vouching for that witness. So you would handle that through impeachment testimony if you told me that you're going to lie. I don't think that you have a duty of candor. You might want to look at the rules carefully and analyze the specific facts of that situation and see if anything would make you think, wait a minute, I think I have to tell somebody here. But I think you can just handle that through impeachment. All right, we're going to move on. We got into Goodwin. We also talked about that comment. That's the narrative. And then comment 9 also talks about unless the lawyer knows the testimony will be false, the lawyer must honor the client's decision to testify. So it's just not me, bleeding heart Susan, saying err on the side of your client. The comment also says this: honor the client's decision to testify. And this we've kind of talked about a little bit already. What if my client wants me to call a witness and I think that witness is going to lie? So again, as I already mentioned, 1.2, the client's in charge of the objectives, but you're in charge of the means. That means you get to decide what witnesses to call and which ones not to. And as I mentioned, if you reasonably believe that the witness will testify to information that is false, you may refuse to offer it. So may refuse to offer it if you reasonably believe, and that's for the witness, not the defendant. But if you knowingly know, that's the first part, that a witness is going to testify falsely, you can't put that person up. So it's a little complicated, a couple of different categories for people, and then different ways of analyzing it. But 3.3 is your place to go if you're dealing with people who are not telling you the truth. And then 3.3b talks about engaging in criminal conduct, and then you do have to take remedial measures. That would be if we're talking about the perjury that your example mentioned, or other types of criminal conduct that the client could be engaging in. And then this is about the evidence that we talked about. If the client wants you to introduce evidence that you know is false, you have to refuse to do so. So let's say the client produced to you an affidavit. Sometimes we have them giving us affidavits that a co-defendant has signed, or they give us affidavits that a girlfriend has signed. We had our DV over here, domestic violence. If they give you something and you know that it's false, you have to refuse to enter that. If you don't know that it's false, you don't have to. But if you know that it's false, you can't knowingly present false evidence. All right. And again, this is where it's specific. Comment 8 makes it clear you have to know that it's false. If you reasonably believe it, you can still put it in, but you may refuse at the reasonable belief. You must refuse if you know. Yes, ma'am. Well, when I was speaking, I mostly meant the document itself. Like if you had the physical affidavit and they wanted you to mark it as an exhibit, somehow you were able to do that, get around a hearsay exception, whatever you were able to do. That's what I meant. Now, if you know that the questions you're going to ask the person are based on false information, then you don't have a good faith basis to ask those questions. And that would tend to fall under 3.3 and other rules as well, rules about not harassing witnesses, not badgering witnesses, because we're not allowed to do that. So if you know that the contents of that affidavit are false, and remember, no, false, that's what's going to trigger that duty, then I would say you can't question about the contents of the affidavit either, because that's still perpetrating a fraud on the court, which is what 3.3 is intended to eliminate. On the other hand, you may not know that it's false. And if you don't know absolutely that it's false, then you can still use the evidence. The second part of that rule talks about if you have a reasonable belief that it's false, you don't have to use it. But if you know, you're required to not use it. That clear that up? Any other questions about that? Because the duty of candor is difficult, and we can, deep dive on that can happen. This is really to scratch the surface. And this is clarifying again. We got that category of reasonable belief, and we got the category of knowingly no. And you need to figure out where you are concerning evidence and witnesses. All right, what do we do with evidence of the client's crime? So, this can come up in some scenarios. The client brings you the smoking gun. Let's hope that doesn't happen. But most of the time we see it when they bring us cell phones. Sometimes they'll bring us cell phones and they'll say there's something on the cell phone. And, what do? They've given you the cell phone. You don't know that it's evidence of the crime. The client's telling you perhaps it's exonerating evidence. Maybe you look at it and you realize, oh shit, this is not exonerating. This is quite incriminating. Or you have clients, we do have some cases where clients have actually given their lawyers guns, drugs, money, things that are definitely part of the crime. So first of all, if somebody gives you something that it is illegal for you to possess, contraband, you can't take it. If somebody tries to give you a bag of cocaine, throw your hands up in the air. I'm done here, right? That sounds easy, right? So then we're going to start with the easy ones. Now, what if the client has given you the cell phone and you look at the cell phone and there's child pornography on it? That is also contraband, and you're not allowed to have it. As an appellate lawyer, we often request the exhibits that you all introduce or that the state introduces in your trials. And sometimes in a child porn case, those exhibits are child pornography. And we have had clerks of court send to us child pornography. Well, it is illegal for us to just possess that, even as part of our representation. We can't have that. That's why when you have one of these child porn cases, they don't give you that stuff most of the time. Hopefully they aren't. You have to go and look at it somewhere. So there's a safe harbor within the statute. So, and I'm speaking specifically as to child pornography. If you find yourself in possession of child pornography, go to the statute, invoke that safe harbor, and protect yourself. It does involve getting law enforcement in the case, but you're going to have to make sure you're hands off of the child porn, because at that point, you're engaging in criminal activity simply by the possession of it, because that is what is illegal, just like the drugs. Yes, sir. I don't have it memorized, but the statute talks about seeking the advice of prosecuting authorities. Like when it happened to us, we immediately reached out to the Attorney General's office and had them come assist us with getting, like, it's now your problem, Attorney General's office. And there, you know, it can get very complicated. You'd want to involve your IT people if it's on your computer or something like that, of how to Chinese wall or actually make sure they can't see any of your confidential client stuff, but that they can get to that child porn. So if you're in a case with a solicitor who's given it to you, call the solicitor, hey, you gave me child porn, I can't have this, and send it right on back and have them talk to you about the safe harbor. I saw a hand. So in your example, the client is coming to you with a photograph or a video. Well, if the client, and the question is what to do with evidence of client crimes, like the client has come and now put them in your possession. And that's what the question is meant to address. But yours is more that the client is asking for advice. And when the client is asking for advice, I think you can advise the client that mere possession of what you have is illegal, or mere possession of what you have is not illegal, or, as often is the case, I don't know. It depends. That's the favorite lawyer answer, because you may not know. If the age of the child is apparent from the picture and you know, then I think you advise the client that what you have is illegal and possession of it alone is contraband, and it's not in your possession at that point. I'm not asking you to rat on your client. What I'm suggesting is if they gave you the phone and now it's in your possession where you're the one who's engaging in illegal conduct. Mm-hmm. Yep. That's the solution under the statute. If you want to invoke the safe harbor under the statute to protect yourself from the illegality of the possession of it, that's what you would do. It's, again, I don't have the statute memorized, so I don't want to tell you yes, no, any of that. I would need to go look at the statute. In our case, it came from the clerk of court's office, so we weren't incriminating anyone by saying we got it from the clerk. I mean, the clerk was dispensing of her duties she shouldn't have, and perhaps was engaging in illegal conduct by sending it, and now that I think about it, actually was. But you can't send it by mail either. That's a federal offense. So in that circumstance, of course, that person wasn't going to be prosecuted for sending it to us. The Attorney General wasn't interested in that. But if they've sent you that video and it's your desire to invoke the safe harbor, you're going to have to follow that part of the statute. If it's not your desire to invoke the safe harbor, you by means don't. You know, you can handle that in a different way. but you won't be protected under the statute from prosecution if they find it later. So if they run one of those torrent searches, you know how they do? If you happen to have one of those things, that means your computer's open. If you're watching videos or games or whatever's going on, and the ICAC unit over at the AG's office finds it on your computer, then you're definitely going to have some difficulty explaining that. Rule 3.4a says that you can't unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal that evidence. So if the client does come to you with evidence of the crime, you can't unlawfully obstruct the state's access to it. Let's remember, this rule runs both ways. Oftentimes, we're told things that we can't access, right, from the state. Oh, I want to get my own DNA expert to analyze that. And they come back and say, oh, you can't have that evidence. Sorry. Rule 3.4 says I can. You can't obstruct my ability to get to it, just like I can't obstruct the state's ability to get to that either. And let me back up on that one too. You can't counsel or assist your client in unlawfully obstructing it either. You can't tell somebody else to do something that you can't do. So if the client comes to you and says, I know where the murder weapon is, what should I do? Well, you don't tell them, hide it well. Don't do that. You can't tell them to do something that you couldn't do either. And you can address that conversation with them about, well, if you tell me that you know where the murder weapon is, then I'm going to be obligated to inform the state of that information. And maybe you can try to work that hypothetical in your client's advantage. Maybe you can't. But you want to have that conversation with your client about the consequences of telling you those things. Yes, sir? So we can... I think you can have conversations with them that say things like, if you tell me X, Y, and Z, I'm obligated to tell the state X, Y, and Z. You can explain to them the consequences of their conduct. I wouldn't go so far as to say, don't tell me X, Y, and Z. It needs to be their choice of the information that they're giving to you. But they need to make that informed decision and know what are the consequences of me telling you that. And many of you, if you go to, like one of your first or second visits to the jail might be with a much more seasoned lawyer in your office. Lots of times you're going to hear them sit down and they're not going to start the conversation with, so tell me what happened. Because they're seasoned lawyers who don't want these types of things to happen. They're going to start oftentimes with, here's what the state says happened. That's where we start. We start with what the state has. And then you can approach hypotheticals with your client of, and this was one that I was involved in, it was a no-body murder, two nobodies. We had negotiated with the state, if we could find the bodies, then our client could no longer have the death notice on him. They'd remove the death notice. So that's what we were negotiating. It was hypothetically, client, if you could tell us where the bodies were, would you want us to go to the state and try to negotiate in this way? Hypothetically speaking, yes, I would. And then we're going to have the real conversation at that point. So you want them to be informed of the consequences of their conduct. You're not just sitting down like, hey, buddy, tell me what happened, because you might find out a bunch of stuff you don't want to know, or that means that you have to tell and rat on your client, which is the absolute worst. None of us want to do that, but sometimes the rules are going to require that we do it. So we can't counsel our clients to do something that we couldn't. And yesterday, some of y'all may remember I mentioned like the video recording, how we can't surreptitiously record. We can't tell other people to do that shit either. All right? So when the DV defendant comes to you and says, she's admitting she lied, she's taking it all back, and you go, well, record it on your cell phone when she's not looking. Do not do that. You can't surreptitiously record. You can't advise that somebody surreptitiously record. So make sure that you don't do that. So comment 2 to 3.4 says you may take temporary possession of physical evidence of client crimes, that cell phone that we got our hands on. And you can do a limited examination as long as you won't alter or destroy the material characteristics of the evidence. So you can't manipulate it in a way that the state wouldn't be able to use it when you inevitably have to turn it over to them. I said inevitably. If it has evidence of the crimes on it, most of the time you're going to have to turn it over, but you'd want to look for specific laws that apply to whatever your specific circumstance is. Yeah. This is happening a lot, I'm guessing, based on the number of times I get this question. The answer that I have to tell you is I don't know. I don't know. I don't know that the answer would be from the Supreme Court or the ethics advisory opinion that if you obtain information that was surreptitious recording, that you could use it. I think the answer would be yes, as long. Uh-huh. Right. It, as long as it satisfies the statute of one party consent. So it would need to fall within our states of one party consent. So one side can consent to the recording. Both sides don't have to consent to the recording. So if you have the one side consenting that it is a legal recording, that as far as your example's telling me, the lawyer hasn't engaged in the surreptitious recording of it. And what I have been telling people is, as far as I know, you can still use that as long as it was lawfully obtained. If you have one that wasn't, then I think it's a different conversation that we need to have. But I think as long as it was lawfully obtained, you can still use it. But right, you can encourage. Right. Right, the one party consent rule. We also have the, I can't remember the name of it, but it was a case where mom was recording dad relating to sexual abuse of the child, and dad and child are on the phone, but mom's doing the recording, so she's not a party, so she's going to fall outside of the statute, but it was a kid. And the South Carolina Supreme Court said mother had the authority to consent for the child. Now, that was a criminal prosecution. I don't know if it would have gone down different in the civil world, but that's how it happened in the criminal world. So mother was able to consent for the child for one party consent. But again, like your obligations, which I'm talking about, you can't do that surreptitious recording, and you can't encourage your client or any other witness to do that either. And when you get the information from your client that is evidence of a client crime, go under comment 2, see that you can take temporary possession of it. Maybe you have your expert take a look at that cell phone, because once you start looking at computers, looking at cell phones, you're automatically messing up the data. You're already manipulating things. So you'd really want to get an expert in there and kind of do some mirror images and stuff. Yes, sir.
Keep the other side bound by our
Well, you're enforcing it through the solicitor. So you're going to court to compel the testing. So it's not necessarily that the solicitor is the one obstructing if you've gone to the police and they've said you can't have access to it. Likely, though, they've gone through a lawyer in the police office who've given them that opinion. And so that person could perhaps have some 3.4 obligations, but you'd be under compelling the release of it through the court system, and you'd likely be invoking more of the discovery rules, what Mark was just talking about, and 3.4 would be something you would add in, because the courts of general sessions, the courts of common pleas, municipal courts, magistrates courts, they're not in the business of enforcing the rules of professional conduct. That's not their jobs. The job of enforcing the rules of professional conduct are Supreme Court. That's who you tango with when you fuck up, not your resident judge. Now, certainly, the rules can be persuasive authority for the judge. The rules can be cited in your motions. Sometimes the rules are cited in orders, but it's not their job to enforce the rules. That's for a complaint to be filed with the Office of Disciplinary Counsel and enforcement through the Commission on Lawyer Conduct and the Supreme Court. So you'd be going in asking for it, motion to compel, putting in 3.4 as additional reason that you should have access to that DNA for testing. All righty, I'm going to keep us on time. This is a pretty recent case in the matter of Gay. Melissa Gay is a lawyer down in the Low Country. Her client was getting into some trouble. She has a telephone conversation that was recorded where she tells the client's girlfriend to remove some money and some paperwork and take it to somebody else. The phones are tapped or whatever's going on, and she has this conversation. The police become aware of it. They charge her with obstruction of justice. She ultimately entered a no contest plea to unlawful communication in violation of the statute. She got a day in jail. She'd already served it pretty much when she got arrested. But then, and this is so we have the criminal justice system acting, and then we have this parallel disciplinary system acting. Her agreement for discipline by consent got her suspended from the practice of law for 6 months. So she had that criminal charge, and then she gets her license suspended for the same conduct. So this is a good real-life example of when your client says, hey, call my girlfriend and tell her to take that money and take that paperwork and give it to Leroy, think twice about doing that kind of thing. Okay, there's an article in The Champion. The Champion's a NACTL publication, so if you want to look at more information, you want to deep dive or a deeper dive into it, you can go there. We're going to get into the sex. Can I have sex with my client? You'd think you wouldn't have to talk about this, but guys, there's an opinion every year that says I do. You cannot, you should not, you don't. It's going to happen. This is a real life letter that I got from one of my clients. This one's not too sexy, unfortunately. As I've gotten older, the letters are less sexy. But you see, I'm going to get out. I'm going to look up, see your name, all those things. So you're going to, he's smitten, which is pretty sweet. So the question, can you have sex? And the answer, as you all know, is no, no, no. Please do not. Rule 1.8M seems to give you some leeway. Guys, don't test it. Just don't. It's not worth it. See the number of cases. This is just a little small amount. Everybody, see, constantly. I don't get it, but don't do it. Just tell them, I'm sorry, we can't do that. Maintain that professional relationship as much as you can. And if you have a situation, like a friend of mine, a former client stalking her right now, if you have that situation come up, reach out to somebody. Don't go through that alone. Reach out to somebody either in your office, a trusted friend, somebody that you can talk to about it, and figure out what you can do, because you do have to protect yourself. Make sure that you're protecting yourself, your safety, and your family's safety as well. Yeah. Yeah. As you said, I always advise the first thing to do is start with a very stern, firm conversation. Nothing you say or do will alter my response, so don't even try. And let's continue on with getting your case resolved and getting you a good result. Leave all that to the side. Now, sometimes that works, sometimes that doesn't work. If it continues and you feel that you can no longer represent this person, like your personal responsibilities to yourself make it so that you can't represent this person, then I would suggest for those of you, and all of you are, in public defender offices, to go to your superior and see if they can reassign this case to someone else. Many will say, all right, that's fine, we're going to reassign this one to somebody else. If that doesn't work, then I would say last action would be to move to be relieved. But generally, I think the stern conversation is going to end it. And as long as you maintain that professionalism at all times, and it's terrible to say, but you will start to watch what you wear more when you go to the jail. You'll start to wear, maybe wear no makeup if you're a woman or a man. Hell, I don't care if you wear makeup. But right, you will do things, and sometimes you do it consciously and sometimes you do it subconsciously if you start to find yourself in a relationship where somebody is making unwelcome advances. But have that very stern, firm conversation with the client out the get-go. Hell no, we ain't playing this game. No. Just make it clear you're not doing it, and lots of times that ends it. But if you do need to reach out, absolutely reach out. I did not know there would be a question about that part of the presentation. Thank you. All right, ending the attorney-client relationship. So 1.16 is about the end of it. Most of us in this room are going to be thinking that the attorney-client relationship ends after the guilty plea, or it ends once the trial is over. Sometimes with a motion to be relieved, it's going to have to end earlier than that. 1.16 is going to tell you when you can do that. There are examples given, but there's a catch-all, other good calls, and sometimes that's where things like we were just discussing would fall. You will also see in Rule 602, I admit this is not a rule of professional conduct, but this is a special request from appellate defense, and it is in the rules, so you have to do it. You have to continue to represent the person until final judgment, including any proceeding on direct appeal, except if we're going to take it, and we're going to mostly take your cases, you're going to be automatically relieved if you were the public defender, but we're going to need your help. We don't know what happened. You know what happened. You know what day your client was tried. You know what day the Jackson v. Deno hearing took place. You know the facts that we don't know. Maybe the case had been called a year earlier and you moved to continue, and something else happened and we need to know about it. So you will continue to have obligations with us as we try to navigate the very beginning of the appeal. So Rule 602, in addition to 1.16 there, and you'll see the little caveat, the public defender shall continue to assist with appellate defense. We talked about this a little bit earlier with 1.2. Do I have to file an appeal? So you're going to get this question in every single case you have, whether your client enters a guilty plea or whether you're at the end of a trial and the client is found guilty. If you get a dismissal, obviously not. If you get a not guilty, obviously not. But in most cases with guilty pleas and a guilty at trial, you're going to be asking yourself, do you have to file a notice of appeal? And the answer is, if the client requests that you do so, you must do it. And that's not just Strickland analysis. I've cited a number of professional conduct cases. So it's not just, he can come back and get his appeal through a PCR. This is also your license. So you want to make sure that if the client requests that you file this notice of appeal, that you in fact do file that notice of appeal. These are the Sixth Amendment aspects of it that gives you the specific language of If it's a guilty plea and the client asks, you must do so. If it's a guilty plea and the client doesn't ask, but you have reason to believe the client would want it, then you do have to do that. And that's the duty to consult, and there's a reason to think either that a defendant would or they've demonstrated previously that they would. And you have to consult with them. You need to explain it in a way that they would understand and make sure they know what their rights are regarding that appeal. I tell people resolve any ambiguity in favor of filing it. Yes, sir. That's an excellent question. And when I worked at the Office of Disciplinary Counsel, many lawyers would try to defend their failure to act diligently by saying either the client has filed a motion to relieve me or I have filed. That does not absolve you of all of your duties to the client while that motion is pending. While the motion is pending, you are still that client's lawyer and you have to continue to act in the client's best interest. If you need to file motions on the client's behalf, you have to do those things. You are not relieved just because the motion has been filed. So, excellent question. Your obligations are still there despite that. And a corollary to that is, what if the client files a complaint with the Office of Disciplinary Counsel against me? Do I hands off? Am I automatically relieved? Do I stop doing anything? No. You continue to act as that person's lawyer. The Supreme Court has said that's not even an automatic basis to have somebody relieved as counsel. The complaint can go forward. Y'all can keep your relationship. Everybody can move forward. So complaint being filed or motion to be relieved being filed does not mean you stop acting as that person's lawyer. Please don't. Keep going forward. All of y'all in this room, you're public defenders, so who's going to be in charge of the appeal? It's going to be the lawyer, and that lawyer for most of you guys will be the gentleman you heard from this morning, and we'll hear from later today, my boss, Bob Duddick. That's who's in charge of most of these appeals. Who in here does municipal magistrate summary court? All right, you're in charge of your own appeals. You're on your own with those. No, we'll be happy to give you some guidance and help at our office, but we don't take those. So you guys have those, and I think you'll enjoy them. I think you'll love them. I obviously do. Yeah. Yes. Right. Yes. Excellent best practice right there. Yeah. Absolutely. You can best practices getting them to put in writing what they want. Remember, you have 10 days to do this notice of appeal, so it's a very short window. I tend to tell people err on the side of filing the notice of appeal, make appellate defense sort that shit out. And we sometimes do. You know, sometimes we get it and we have to go, okay, they had 10 days. They went ahead and filed it, get it, because they send them to Kirkland. And lots of times they can't even get a phone call during the first 2 weeks. So tracking them down, getting in touch with them can be really difficult. So if you find that yourself in that situation, best practice, go ahead and file that notice of appeal. That way that right is protected. But best practice is for waiving that appeal, get them to do that in writing. Talk to them that you have a duty to consult with them and make sure they know their rights and that they're making an informed decision, so you can get them to waive that. And yeah, that's why Roe versus Flores Ortega came out, because people would say things like, well, he wasn't sure. I didn't know if he wanted an appeal. He never said. And so they created that language of, if a rational defendant would want one, then you have to file it. Or if there's anything that happened that you would reasonably believe that your client would want it, you have to do so. Well, like what if they'd been found guilty of a lesser included? And y'all, they had gotten, or maybe they got the minimum. You got a good judge who gave them the minimum, and you might have a client who doesn't want to mess with that. Go ahead, Breen.
So that usually part of the conversation you want to have even before you.
Absolutely, yeah. You want to go ahead and start talking to your client about the appellate process ahead of time so that they're primed for that conversation that you need to have at the end of the case about it. All right, we are almost at the end, so I'm going to let you guys read the rest of these and ask questions that you may have. Those of you who will be doing your own appeals, if you want to talk about those, feel free to call anybody at Appellate Defense. This question is one that I think comes up all the time. The file belongs to the client. You just have the privilege of working on it. So if the client demands the file, I would suggest you have a conversation with the client that explains to them the risk of having that file, particularly in jail. But if they are insistent, it's their file. And unfortunately, if they write to the Office of Disciplinary Counsel is going to tell you what I just said, that the file is theirs and you have to give them their file. And if you want to talk about specifics of that, the voluminous files, digital things on the file, we can talk about all those things. But anybody have any questions before I turn it over to Ms. Wanda Carter in the back? Yes, sir. So the preliminary hearing can be waived by the lawyer. That's not a trial, so it's not specifically can the lawyer waive the jury trial or can the client. That's specific to the client. Only the client can waive a jury trial. Only the client can decide to enter a guilty plea. The lawyer can waive a preliminary hearing. I would try to do that in consultation with my client if possible. I know that's not always possible, but you can waive that as a matter of strategy, a matter of tactic. Yes, ma'am. So that's a really good question and one that comes up when you're having to give the file over. What I used to do when I had a lot more client contact than I do now is I would have the memo that I would write to be like just the facts, ma'am, and then I'd have a separate part that would be my impressions so that those things could be redacted out if needed to give over to the client. If you may want to keep a method of all the times you've met with the client so that that kind of information can be transmitted to the client. But I don't think that you have to give over all of your work product. Several years ago, the Professional Responsibility Committee attempted to get the Supreme Court to adopt a rule defining the client file, and the Supreme Court said no. They like it to be flexible. They like it to not be very defined in the rule about what constitutes that file. I would imagine that many lawyers, particularly civil plaintiffs lawyers, are not going to want to hand over that full file because it's going to have, the motions that they've prepared for the next 3 stages of the case. And so they're not going to want to hand that over. So I think it would go that if we get a case on it, it's going to come out the way of you don't have to hand over all of your work product and that type of thing. But you would want to hand them the discovery. If they insist, I do think you counsel them against it, the discovery that comes, you'd want to hand them over like motions that you filed on their behalf and things like that, and maybe generate a list of them of all the meetings that you've had with them. Because if they go to complain to disciplinary counsel about she doesn't come talk to me, that's going to be your defense of these are all the times that we met. Any questions? Yes, sir. The trial lawyer, it is your duty as a plea lawyer or the trial lawyer to file and serve that notice of appeal. It's not the lawyer who hasn't been retained to do the appeal. It's the lawyer who did the trial, who came to the end of the plea. Even if your retainer agreement or even if your contract with SCCID doesn't require you to do the appeal, you still have to file and serve the notice of appeal. My name, number, all that stuff is at the very end of this somewhere. It's in your materials. I'm on everywhere you can find me on the bar's website and stuff. Reach out if you want to call me, email, any of that good stuff, anybody at Appellate Defense as well. And I'm way over time, and I'm so sorry about that. Thank you very much for having me. I appreciate it.